If you own the property and it's got under 80 years on it already and you own it outright and you're prepared to wait, well, I guess you could say I might choose to wait and see if the law is going to be reformed. If it's your property and it's about to go under 80 years, probably better to take action, even with the law as it stands, because serving that notice will peg the valuation date and prevent you from going to a situation where if the law doesn't change or doesn't change as anticipated, you'll end up paying more money. But it's a very much a balancing act.
Welcome to Listen Without Prejudice, your exclusive gateway to one of London's leading law firms. In each episode, we dive deep into the stories, insights, and expertise that make Bishop Sewell a trusted name in the legal community. Join us as we explore everything from the latest legal trends and case studies to practical advice on residential and commercial property, corporate and commercial law, employment, family and divorce matters, private clients, and dispute resolution. Whether you're a legal professional, a client, or simply curious about the law, Listen Without Prejudice is here to inform, inspire, and engage. Now, without further ado, let's get the conversation started.
Hello and welcome to the show. I'm Mark Chick, Senior Partner at Bishop Sewell, and with me today is Chris Macartney, Head of our Landlord and Tenant Team, and we're going to be talking about leasehold reform and where are we now. Chris, hello.
Good morning. How are you doing? It's a nice day today.
Indeed. Welcome to the show.
Absolutely.
We're going to chat a little bit about what's going on in leasehold at the minute, aren't we?
We are indeed. It's been an interesting past 20 years or so. The recent Leasehold Reform Act came in on the 24th of May 2024, but of course we've got a lot of history over the last previous years.
But it might be quite good to look back into that history and just move back through the brief sort of story about that. But before we get on to that, I mean, perhaps we should just say a little bit about what leasehold reform is. What do we mean? What are we talking about?
Yeah, well, for the context of leasehold reform and for these purposes, what we're generally referring to is the rights that leaseholders have in relation to residential leasehold property. So a lease, of course, is a time-limited interest in land. Something like a fifth of the property in the country is leasehold property, predominantly flats. So what we're talking about for the purposes of this show is what rights people have, the history of that, how we've got to where we are now, use and enjoyment of property as flats, and what rights people might have and how it's been affected by the recent legislative change.
Yeah, and I think maybe most people may be aware that because it's been much more in the news recently than it was, but I mean, we're enfranchisement lawyers, it's something we've been sort of grown up with. But I mean, collective enfranchisement, the right to collectively take over the ownership of the freehold of a building. It's not an individual right.
No, indeed, they're collective rights. So for the purposes, again, of this show, a lot of the things that we tend to focus on, as Mark and I are leasehold reform nerds, this is what we specialise in, doing it for quite a long time. Collective enfranchisement is the right of a bunch of leaseholders in a block of flat to take collective action against their freeholder. You've got the right to manage as well, which again is a collective right for groups of leaseholders in a block of flats to be able to take initiative and take over the right to manage of the building from the freeholder or whoever has that right in the block, because it's not always as straightforward as you might think it is.
No, and indeed, when we say this collective action, I mean, how many people wouldn't be needed to take part in that?
Okay, so taking it down to brass tacks, generally speaking, it can be as few as two people, so two flats in a converted building, say, which has been split into two flats, to as many as 200 or so. And we both have acted for many tenants in the former, where you've got small houses where people are looking to predominantly buy the freehold in those sets of circumstances. In larger blocks of flats, currently, it is, generally speaking, more attractive for leaseholders to buy the freehold because it's seen as an absolute end to removing the freeholder from their involvement in a block. And right to manage has traditionally been seen a bit more of a sort of second-class interest, or right, I suppose, to take collective action in relation to a block, but it's becoming much more popular now, which probably is something to do with the reforms.
Yeah, and that magic 50% figure that people mustn't get to in order to collectively enfranchise. I mean, obviously, when there's only two flats in the building, as you said quite rightly, both of them must take part. You can't just do it as a singular right. There's also a right under the 1967 Act to buy the freehold to a leasehold house as well.
There is. So that's an interesting right that has, so the 67 Act has been around for quite a long time now. So what is a house, Mark?
No, well, that's a good question. It's one that's been to the Supreme Court on 2 or 3 previous occasions. And indeed, something that's been settled in case law. And ultimately, if it's not a house, it will be a flat, you'll be pleased to know. But as regards a house, it's got to be suitably set out like one. It's got to look like a house, it's got to be adapted for the purposes of living in. And also the lease itself may be material as well. So that 1967 Act right to buy in the freehold would apply to a lease where the flat owner or the house owner has the obligation to repair the interior and the exterior of the property. If they've got a lease that's more like a flat lease where they've only got an interior repairing obligation, there's an external service charge, then that's not going to qualify. There also is a physical distinction between what separates one piece of property from another. I know we could spend a long time talking about qualification generally in qualifying buildings, but for a leasehold house, you need no significant overlap or undercut with any adjoining property. If you have that, and there's a big overlap or part of another property cuts in underneath it, and it's more than a significant percentage of floor space, that won't qualify. So there's lots of tricks and traps to this, aren't there? Lots of twists around the qualification process, all of which are quite detailed.
Yes.
But the basics are reasonably straightforward.
Yeah, indeed. So as we alluded to, the what is a house has been litigated many times, from as far as the House of Lords or as is now the Supreme Court. Something that you're seeing less frequently at the moment. Again, probably on the basis that many of the leasehold houses that were granted previously have been enfranchised now. So
certainly in central London, I think that might be more true, yeah.
Exactly. So in terms of the legislative history of leasehold reform, where have we got to in the more recent history? So we've had the 1967 Act, which was the rights that were given to leaseholders to buy the freehold of a house. There was the 1987 Act, which we're not going to go into too much detail today, which sort of switches the onus. So the 67 Act and the 1993 Act, which I haven't got yet, is where you force the freeholder to take action. Whereas the 1987 Act tends to be where the landlord is looking to dispose of an interest, but I'll park that for now because we're probably going to talk about that in another show, I think.
Absolutely, yeah.
So we had the 67 Act, the 1987 Act, then there was the 1993 Act, which is the Leasehold Reform, Housing and Urban Development Act 1993, which is a snappy title.
Best called the 1993 Act,
Indeed,
I think, yeah.
Which is the piece of legislation that gave us the rights for collective action, so collective enfranchisement, and the right for lease extension, which is work that Mark and I see an awful lot of in our practice. And then moving on from the 1993 Act, there was the 2002 Act.
So that changed the qualifying criteria. So without giving a history lesson, before the 2002 Act became law in 2003, you had to have owned the property for periods of 3 years amounting to, in the last 10, and had it as your principal private residence. You couldn't enfranchise if you were a company. All those requirements are swept away. And the ownership requirement for lease extension and being a qualifying tenant was reduced simply to 2 years ownership. And in the case of a collective, you just simply need to be the flat owner. The house requirements were similar to the ones I've just mentioned for the lease extension. So there was a big opening of the floodgates, if you like, and it became much easier to bring a collective action. And indeed, the qualification criteria got changed as well. So previously you had to have 2/3 of the people in the building looking to do this. Now, then that was then reduced down to 50%. So not even more than 50%, just purely 50%. And that, of course, made these rights much more accessible. That's without saying some other things around some of the subsequent changes that happened after that as well. So there were specific requirements around the signature of notices. Those were changed by the Leasehold Reform Ground Rent Act 2014, which meant that no longer did the tenant have to personally sign the notice. And both you and I were in practice during that time. That was quite an interesting amendment to the law. One of my ALEP colleagues actually dealt with some of that. And there was a private members bill that amended the main legislation. So it's a particular perceived difficulty within the legislation, something that I and a number of ALEP colleagues worked on to try to bring about a simple but meaningful change.
Indeed. I mean, so I suppose under the 1993 Act, there are a number of trips and traps that people do tend to get caught by. And the Leasehold Reform Amendment Act 2014, in amending it so that you didn't have to have the leaseholder signing the notice, actually, that was quite an interesting point, because there are a number of provisions within the 1993 Act which the new LAFRA, the Leasehold Freehold Reform Act 2024, seeks to amend, which is those sort of administrative amendments, isn't it? Which, so obviously the service of notice has already been dealt with. There's the 2-year rule as well. So currently, if you're looking to extend the lease of a flat under the 1993 Act, before you can start that process and exercise that right, you have to have owned the property for 2 years. And that's one of the provisions that's being swept away under the 2024 Act, which is going to be quite interesting, I think, isn't it?
Yeah, it's going to make it easier to get on with bringing a claim. Absolutely. There's also going to be a removal of the restriction on bringing a claim within, if you bring a claim and you withdraw it at the moment, you've got to wait a year before you can bring another claim. And perhaps in a minute we can go on and explore some of the major changes around the 2024 Act and what that will bring in. Also, perhaps worth mentioning the 2022 Leasehold Reform Ground Rent Act. You can see why this session's all called Leasehold Reform, Where Are We Now? Because, of course, it's been the title of so many of these acts. And so you might ask the question, why does leasehold need reforming? So let's just pause for a moment and talk about ground rent and why that might need reforming.
Yeah, well, okay, so the Leasehold Reform Ground Rent Act 2022 removed ground rent from all leases that were granted. Meant that
30th of June 2020.
June 2022, thank you very much. So that meant that any new lease that was granted after that date could no longer reserve a ground rent, which has made a big difference, I think, because there's the ground rent scandal that you may or may not have heard about, which has been where property granted on leases reserved quite substantial ground rents. Historically, ground rent was supposed to be a sort of a token payment towards the landlord to reflect the loss of and use and amenity of the land whilst it was let for a long lease. And typically, it used to be a set amount that would probably increase at stepped increases at set times over the term of the lease. During the 2000s and sort of the 2010s, you tended to see more leases being granted at really extremely high ground rents. So there'd be doubling every 10 years, for example, from quite a high base, which could then suddenly mean the value of your flat or house was completely worthless, or other increases that were linked to RPI, for example, which isn't necessarily such a bad thing, but if those increases are quite regular, say every 5 to 10 years or so, which you do see, again, it made it less certain. Mortgage companies, for example, don't like it. So the Ground Rent Act 2022 removed that, basically said that any new lease granted after June 2022, you can't have a ground rent in it, otherwise you will be fined.
No, absolutely. And there are lots of enforcement through the local weights and measures. There's fines, there's all sorts of things that will be imposed if a lease is granted in breach of that. Now, it is possible still to renew a lease where you're paying a ground rent if you do it on a voluntary basis, but the ground rent must only run until the old lease term would have run out. And so that's perhaps the only exemption to that now. So an existing lease being renewed, if it was a 125-year lease and you add another 50 years onto the unexpired term, and let's say it's got 60 years to run at the minute, the ground rent can run until the end of the existing 60 years, but in that new 50-year period, no ground rent whatsoever could be charged. Perhaps, also worth reflecting on the fact that some of these ground rents were a bit of what might be seen as being a market abuse. The principle of a ground rent, at least as we both know, doesn't need to contain a rent as a matter of law. Historically, leases have had rents in them because that's been something which has always been a feature of leases. Public perception of a lease is you have a space for a period of time and you pay a rent, but the rent, of course, could be purely notional. It could be a peppercorn.
Yeah, or a red rose, for example.
Yes, indeed.
All things that you've seen in the lease. So, yeah, I think that's probably worth pausing and reflecting on the fact that it was a bit of a market abuse over a set period of time, and it was definitely taken advantage of. I mean, again, traditionally, without going into valuation principles, a flat would usually be valued on the basis that it does retain a ground rent, and the price would reflect that, and the fact that it was a time-limited interest as opposed to a freehold interest, whereas I think that possibly has been lost a little bit.
Well, I think a modest ground rent wouldn't necessarily cause a problem. If you're paying £250 a year for the remainder of the lease term, be that 125, 150 years, 200 years, that's likely to be affordable. The problems start when that sum becomes unaffordable. And the particular difficulties of the so-called leasehold scandal arose around developers, particularly taking houses for some reason, because they could be sold leasehold, they didn't have to be, but they were, and putting reasonably aggressive ground rent provisions in them. And perhaps another thing that you and I, Chris, would probably reflect upon on this is about perhaps the adequacy of advice, because I think one problem that people have seen in the past has been the difficulty of getting good quality advice, reading the contract properly. A lot of these schedules with the so-called time bomb ground rents were buried at the back of documents, people waving things through what might be called a conveyancing factory in sort of slang parlance. And so people being signed up to things they probably never should have signed up to in the first place, with unfortunate results.
Yeah, it all goes back to, as you were saying a couple of minutes ago, abuse of the sector. It was just, there's no way that those properties should ever have had anything like that. But I think that the fact is that people did sign up to it. So the documents that set out the title to the property that they were buying included that information, and they just weren't advised on it, because I'm fairly certain that most people who bought property wouldn't have bought them had they understood what the implications of that ground rent would be. And clearly, most mortgage companies would probably wonder why they were being sold that as good security by the solicitors who were purporting to act on their behalf. But there we go.
Well, I think it's also something else that we can see a lot of high-value property in central London where historically there have been leases with quite high rents on them, and that's perhaps a different thing. But then you're probably looking at people that have had a better quality of advice around that, understood what they're doing. They might have chosen, or those might be the only terms on which that was available. But perhaps the other thing that comes into that is good quality valuation advice as well, and knowing what it might cost to buy your way out of a contract like that, something which probably was just glossed over on day one.
Yes, indeed.
But perhaps, good news for leaseholders, the legislative dial has shifted now.
It certainly has. And particularly with ground rents, that has been because one of the problems that you see sometimes, in fact, I spoke to somebody only the other day, they had very, very long leases. Flat was sold on a 999-year lease 20 years ago, but the ground rents that was with it was particularly high, and it's pegged to the capital value of the building, which increases every 15 or 20 years, I think it was, which isn't acceptable to the majority of lenders, as you know. But one of the new things that will hopefully come in at some point under LAFRA 2024 is the right to buy at your ground rent.
Absolutely, yes. Well, let's pause for thought on that, because I think a lot of things that we've been saying about ground rent, it's lenders that have driven this to a certain extent about what will and what won't be acceptable. There's been some voluntary action in the market by some of the ground rent owners who have actually signed up to reduce ground rents or put them back to things where they will change by reference to RPI rather than simply doubling. But if the ground rent exceeds a certain fraction, around 0.1% of the capital value of the property, it's generally seen as being onerous, and therefore from a solicitor point of view and a conveyancing point of view, it becomes much harder to advise a bank to then lend on that asset. And that has been a problem for people as well. As they've come to refinance these assets, they suddenly realise there have been these problems. Now, that doesn't necessarily solve all the problems for existing leaseholders, but as you've just rightly said, Chris, the ground rent buyout right, which is a totally new right, so a new species of enfranchisement right, is something which is in the 2024 Act. And that will, in time, when it's in force, allow a leaseholder to serve a notice, a bit like a lease extension notice, seeking only to buy out the ground rent. And the reason for that is, of course, if you've got a lease which is long, 150 years at the moment, you may not need to seek a lease extension, but you may not want to pay the ground rent. You certainly may not want the future escalating ground rents which are there. So there will be a process under which a notice can be served, a counter notice will be given, and the ground rent will be bought out for a price to be either agreed between the parties or determined by the tribunal in the similar way that you might under the existing bits of the enfranchisement legislation. But that's very much terra incognita because it's not law yet. It's on the statute books, but it's not yet in force.
Well, that's a process that we're very familiar with, isn't it? Notice, counter notice, negotiation, and then completion or determination by the tribunal in the absence of agreement.
Well, there's some other news as well for leaseholders as well around ground rent per generally, isn't there? Because the last government consulted in December of last year, December 2023, around what might happen in terms of reforming ground rent for people that are paying it at the moment.
Yes. And the cap of ground rent as well, or removing it. I don't think that's necessarily been quite the story that people had hoped it would be just yet, but it remains to be seen because, of course, we did have the Act that was enacted on the 24th of May 2024, my wife's birthday, so I will always remember that date. But it's yet to be commenced, isn't it?
Yeah.
And have you got any update for me? Because I keep looking for it and it doesn't appear to be there.
I think everybody's asking that question, aren't they? So there's a couple of things. On the ground rent point, the government consulted on that and hasn't produced the last government, the Conservative government, didn't publish the results of that consultation. In the intervening time, there's been a lot of discussion about whether there might be a challenge on human rights grounds to some of this stuff as well, which is something else we'll come back to in a moment. In terms of timing to the actual sending the Act itself live, there's nothing particularly clear about that. I mean, the previous government had said it wanted to consult because I think before we can talk about what is going to come in and when, we perhaps reflect a bit about what the changes that Act is actually going to do, because there are some pretty significant changes there. There were much reported at the time.
Indeed.
Quite headline grabbing. I mean, you sort of woke up to a headline saying all lease extensions will be 990 years and they'll be for free. Well, that's not quite right. So there will be a new right to have a 990-year lease at a nil ground rent. The valuation mechanism is going to change significantly. There's going to be a restriction on the perceived level of ground rent for valuation purposes regardless of the actual ground rent. So that's going to be restricted to 0.1% of capital value. And the concept of marriage value, this thing when a lease gets under 80 years, which makes it more expensive to buy the freehold or extend the lease, will be removed from the calculation. So that's another big change. And that's going to be a big thing for people to think about.
So turning to the commencement date of the LAFRA 2024, Mark, we've talked about broadly, the history of the Act. We've talked about some of the history for the legislative change that drove the 2024 Act. What we haven't necessarily buttoned down and focused on is what those amendments look like.
Yeah, I think it's really worth explaining that for the benefit of our listeners, isn't it? So there's some significant major changes. The first one is the abolition of the 2-year rule. So at the moment, to extend your lease, you'd have to have owned the property for at least 2 years. That's going to drop away. Similarly, the new new lease extension rather than adding 90 years on to the unexpired term. So not a plus 90-year lease extension, it'll be a plus 990-year lease extension. So it's never going to need doing again. At the moment, if you bring a claim and you withdraw it, you have to wait a year before you can bring a further claim. That will also be swept away. So you'll be able to withdraw a claim and then start another one more or less the next day.
What about costs?
Well, cost is a big issue, isn't it? So at the moment, the tenant will pay the landlord's costs of dealing with the investigation of the notice, the service of the counter notice, the conveyancing on the transfer or the grant of the lease. They'll not pay the litigation costs, but they will pay those other costs. And those costs have to be agreed or determined by the tribunal if they can't be agreed. And in the new world, when the 2024 Act is law, those cost provisions will be swept away. So each side will have to pay their own costs. So it will cost the landlord money to deal with the claim that comes in. So that is a major change. Obviously, a very big point in favour of tenants, perhaps.
Yeah, it'd be interesting to see how that impacts negotiations from a landlord's point of view, because they may not necessarily want to spend quite so long negotiating, although, of course, negotiations aren't recoverable costs anyway. But it'll be interesting to see whether or not they decide to retain the same standard of advice that they currently have, because I can certainly see a world where you get some landlords who may not necessarily be prepared to pay the same costs that are being currently charged to the leaseholders, but we shall have to see.
Indeed. It's something that's currently the subject of some discussion. I think that's something that's got to be thought about quite carefully, because sometimes you can have a low value claim that's not necessarily, just because it's a lower value premium, not necessarily to say that it's not complicated. And there can be frustrations if people are not able to recover their costs. Will they deal with these claims properly? That's another question that needs to be worked through. And I think that's something which is yet to play out. We don't know when these changes are likely to come into effect.
And of course, on costs as well, if the premium payable for the lease extension is sufficiently low, there are instances where actually the tenant will pay or at some level of
contribution
compensation
towards cost, potentially. Absolutely. So this is something else that's currently being looked at as well. I think it's worth just pausing for thought on that. I mean, all of these changes, they're not going to come in necessarily immediately. They may not come in at the same time. The previous government said it wanted to consult on the changes in relation to valuation reform. And perhaps let's just dwell on that for a moment as well, because I think that's the big thing that's in people's minds, the cost of doing this. I mean, ignore perhaps the transactional cost, but the marriage value cost, if the lease is under 80 years, that's going to be removed. That would be a big incentive for flat owners.
So currently, for a lease extension, say, let's take a simple valuation calculation. Valuers, there are no such things as simple calculations and valuations, of course. But in principle, what are we looking at? When you compensate a landlord for the cost of a lease extension and the lease is under 80 years?
Two things, really. So you're buying out the ground rent that currently exists under that lease. That needs to be capitalised. And so the compensation question is, what equivalent sum of money would you have to give the freeholder for them to receive an income like the income they're currently getting from the lease? So that's a calculation which can be done using a capitalisation rate, and the valuer can work out a number that can be applied to that. And historically, capitalisation rates have been in the range of 6 to 8%, and it's possible to come up with an income fund that will generate a payment equivalent to the ground rent they're currently enjoying. Obviously, the higher the rent, the longer the lease, the bigger that number needs to be. But in a general enfranchisement calculation where the ground rent's not particularly high, it's not the most significant amount of money usually. Then there's something else we need to take into account as well, which is, of course, what happens when the lease expires, the so-called reversionary value. So sometimes valuers speak about what's called term and reversion. What they mean by that is the ground rent, but then also the right to get the property back at the end of the lease term. So if your 50-year lease were to expire in 50 years' time and you did nothing else, the freeholder would end up with the flat back in their hands. Now, there are various things that mean that may not happen. There are rights to renew the lease, what we've been talking about. There are rights to remain in the property, paying a market rent. But assume for valuation purposes, because that's what the law does, that none of those things happen. Then you're in a position where you've got to take the capital value of the property and say, what would an investor pay now to receive that asset, let's say, in 50 years' time? And that's a calculation that be done using something called a deferment rate. So in the same way you might look at an accumulation rate over the time costed value of funds over time, here's something which says the future purchase value of this is I'll pay this today to receive that tomorrow. And I mean, it doesn't take a genius to work out that the closer that the tomorrow is when the lease expires, the higher that sum of money will be.
Yes. And of course, deferment rates are something that are quite controversial in the context of this new legislation. But let's just park that for a second. And what's the final element that you pay?
Well, okay. So if assuming that those two things, we talked about a lease which is over 80 years. So those are the only two things you need to think about, generally speaking, within that. Under 80 years, of course, you're going to be talking about a situation where you've got to pay marriage value. Now, marriage value recognises there's an enhanced value owning both the freehold and the leasehold assets and putting the two back together again, the uniting, the marrying of those two interests. So in a funny sort of way, it's a bit like the same separation value might be seen as having a negative impact on the value. Now, you've already paid in the compensation calculation for the lost ground rent, and you've also then perhaps paid for the deferred lump sum value for the freehold, the term and the reversion. But if you just pay those things, if the flat has a lease that's under 80 years, it's likely to go up in value by more than the amount you've just paid. And so that additional jump in value, less the two things already paid for, is effectively a profit that's made on making the lease longer. And that, as the law stands, it has to be split 50-50 between the leaseholder and the freeholder. So hence the so-called marriage value, and hence the landlord having half of the so-called marriage value. So at the minute, if your lease is under 80 years, that amount will increase the premium. It's not possible to give a precise piece of guidance because it does depend on the values, etc. But, it could make it up to a third more, half as much more expensive again to extend the lease. So it's why we both always say to people, look at the lease length when you're buying a property or when you've got a lease that's near 80 years. Under 80 years will be a big jump in the amount of money it's going to cost you to enfranchise.
Because that does get triggered just overnight. So if your lease on the day has over 80 years, overnight it will suddenly become more expensive, substantially more expensive to extend your lease. But it doesn't necessarily increase sort of in a linear way, does it? It's not a consistent increase. It's like a graph with a big curve in it, isn't it?
It is. There's a relativity curve that shows that, and we're probably going into more than we need to do for the basics now to look into that. But that's been the subject of much case law and much debate. I mean, marriage value as a concept is a continuum. It exists beyond 80 years, but it's just the law arbitrarily, when it was reformed in 2002, said, well, we're going to switch it on only for leases under 80 years. Before that, it could be argued for at any point in the lease length.
Yes, it was quite interesting and has caused much furore about it as well. So it'll be interesting. Presumably, there's quite a lot of landlords who have probably baked into the investment value that they got when they acquired these interests. They're going to be losing out on reasonably considerable amounts of money if they not abolish ground rent, marriage value, because as you've just said, you can't abolish a concept. It's just removing it from the calculation.
I think that's absolutely right. I think let's drill into what the 2024 Act means for us in terms of valuation. So not only will marriage value no longer be a factor, but also there'll be an assumption that the ground rent that's paid doesn't exceed 0.1% of the capital value of the property. And that's regardless of whatever the ground rent actually is. So if the ground rent is £500,000 or £1,000, if that amount is more than 0.1%, then work out what 0.1% of the actual capital value is, and that's the maximum amount it will ever be deemed to be. And that's a big gift into the hands of the leaseholder, because one of the government's stated objectives was to make it cheaper and easier for people to do this. And of course, this will certainly make it cheaper. So that's another factor. The valuation basis is now going to be called something called the standard valuation basis, this term and reversion calculation with the assumed capped ground rent, whether it is or it isn't. And these restrictions are going to be narrowing down various things to do with how intermediate interest and other things that make leasehold reform valuations a little bit complicated. They're aiming to simplify them. Whether that will work in practice, it's not quite clear. I think the other thing that needs to be said as well is that certain things will be excluded from this sort of simplification. So leases that are less than 5 years won't be dealt with in that way. They're dealt with in a completely different way. And where there is other additional value, the so-called development value, if you like, where a property, particularly the collective, could have further work done to it to make it more valuable, and that can be shown to be the case, well, that's still available as well.
Yeah, there are some other changes in the legislation insofar as they relate to collectives as well, isn't there? So at the moment, there's the 25% cap on non-residential property that's being increased to 50%, so which is bringing more buildings that would otherwise not have been enfranchisable are now enfranchisable, which will be interesting to see. Possibly a bit of a concern if you've got commercial property, because whilst these legislative change is a good thing, generally speaking, there are some unintended consequences of it in so far as how they will impact the market and what people's rights and landlords' interests as well.
Well, I think people are going to be looking at more combined management. So you're going to have areas where, for instance, if that threshold changes, which it will do, or if and when it does, it's quite likely leaseholders will bring properties with mixed use into their own management, and the commercial interests and the leaseholders are going to have to sort of have an interplay about how they're going to work in terms of, let's say you've got flats built above a shopping centre or something similar. Perhaps this was never something which the enfranchisement legislation would, envisage would be in the hands of a collective. So there are some interesting things to think about there and how that is going to play out in practice. Perhaps also worth mentioning a couple of other things. There's going to be a mandatory right to compel the freeholder to take a lease back of an area. And that means that if an area like a commercial premises at the minute doesn't have a long lease in place, if that lease is paying a high rent, say it's paying £100,000 a year because it's let to a valuable tenant, it would cost a lot of money to buy that out. What you can do now will be turn around to the freeholder and say, no, I want you to take a lease of that area. You can hold on to that. I'm buying the freehold, and that has to stay with you. And that will also achieve the objective of reducing the cost.
Yes, it will. That will be interesting. I'm sure you have. I have certainly acted for tenants where we've had to make a claim to buy the freehold and it increased the premium payable to the landlord by a substantial amount to reflect the fact that there's a commercial tenant in there which is paying market rent to the property on a short lease. So
there are other changes as well. They're very technical. They concern what we would call intermediate interest. So there's this thing about what happens if you buy out in a collective, the leases that might sit above your lease, and now you won't be mandated to buy all of those. You can buy parts of them. There are changes in the rules around areas outside the property, just in terms of how those rights are going to be partitioned. So there are some changes for practitioners as well, all geared up to make the process simpler from the point of view of the leaseholder. But the implementation of those is a different thing, I think. So, yeah.
Well, it'll be a very interesting time. It will be interesting to see notices being served and drafting those notices myself, because it's going to change our practice quite significantly, I think, as and when it comes into force.
Yeah.
Of which... Any idea of dates, Mark?
Well, I think that's a bit of a difficult question. No is the short answer.
And why is that?
Well, previous government said in relation to valuation reform, it wanted to take some time for the market to adjust. So there would be some consultation before these significant changes, such as the removal of marriage value from the calculation, came into force. We've also got to look at the interplay with ground rent, whereas although that's not in the 2024 Act, there's this still unanswered question about the ground rent consultation, the results of which haven't yet been published, and maybe they won't be published, because there was a suggestion that ground rents might be capped. Initially, there was a suggestion that something could be done for all ground rents. And if you look now at the King's Speech, we've got the prospect of yet a further bill in this area. So there's a leasehold and commonhold reform bill looking at the reintroduction of commonhold, which is already on the statute books, but not entirely fit for purpose. Once again, another longer topic, which we'll have to park for another day.
Yes, well, just on commencement, I mean, so there are some provisions from the 2002 Act that have not yet made it into law. So
indeed.
Interesting.
See the example of the right to enfranchise company for further details. Absolutely. I think that's perhaps an important point, that is, whilst this is on the statute books, not all of it will necessarily come in. It's likely it will. To come back to the ground rent, the reason I was mentioning that is because one thing that was mentioned during the passage of the Act and has still been discussed is whether there are human rights grounds on which this legislation might be challenged. If you took away all ground rent, for instance, would that be something which goes too far? Now, I'm not in a position to answer that question, but it's more likely that some kind of control over those rights is more likely to fall in favour in the human rights arena, something else that we won't necessarily delve into now.
It's certainly not my area of specialty, so no thanks.
But there are some challenges that have kicked off now, one of which relates to a specific piece of legislation involving Annington, where they've been involved in a large rent review negotiation with the government. And there's a very technical piece around what the enfranchisement rights mean within that legislation. There's an application for judicial review that's gone in there, because they're saying, well, the government shouldn't be allowed to change the law to benefit themselves in that situation. But also recently we learned that the John Lyon charity, a charity that would own a lot of property in central London and would end up benefiting quite a lot from marriage value particularly, has brought a challenge based on the human rights ground that perhaps the shift in this legislation that away from the ability to receive that income obviously denigrates their ability to carry out their charitable work. And was that really what should or could have been intended? So those two things are there, and there may be other challenges yet to play out, all of which might move into the timeline in relation to the enforcement, the implementation of the legislation itself.
It doesn't sound like it's going to be any time soon, does it? So what to do in the interim then, whilst we're waiting for the new Act to come into force? It doesn't, what with the pending litigation from Annington and John Lyon's charity, plus the other difficulties and complexities, what are you saying to clients at the moment?
Well, it's difficult because I think it's very case specific. There is no one-size-fits-all solution. I think that's the thing to dwell upon and reflect upon really importantly. So, we are not the client. We can't tell the client what to do. If you own the property and it's got under 80 years on it already and you own it outright and you're prepared to wait, well, I guess you could say I might choose to wait and see if the law is going to be reformed. If it's your property and it's about to go under 80 years, probably better to take action, even with the law as it stands, because serving that notice will peg the valuation date and prevent you from going to a situation where if the law doesn't change or doesn't change as anticipated, you'll end up paying more money. But it's very much a balancing act. If you want to sell or remortgage, as the law stands at the minute, you probably may want to take steps to protect your position there, because otherwise you're stuck in a situation where someone else is probably going to ask you to do that, and you've got that difficulty that you're not then able to freely convert the property. So it is very much a fact-specific explanation in each case.
Yes, I suppose if you've got over 80 years at the moment, I mean, the only thing that you would really save would be the capped ground rent and the costs. So I'm certainly saying to a lot of people at the moment I speak to, you're better to buy certainty at the moment, because at least then you can just get on with your life and not have to worry about this.
I think that's right. I think whilst a lot of this is much vaunted, actually you need to look into the facts and circumstances of your own case, because if you've got a fairly straightforward case, is there ever such a thing, but your lease is over 80 years, you may well, as you've just said, Chris, be better off just getting on with it, getting the job done now, and then not having to worry about it again.
Indeed. And there's also, if you've got particularly short lease where the marriage value has reached its peak and is reducing down in terms of the element of the premium that you would have to pay, in those circumstances as well, then obviously removing ground rent is going to have less of an impact, but the lease is probably getting a lot shorter, and so that reversionary value is increasing.
That is something that's really worth dwelling on, actually. Perhaps that's a good point to bring things towards a close, because actually if you've got a lease where the lease is, say, 10, 15, 20 years or under 50 years, then you are in a situation where the marriage value is not such a significant aspect. It would be a pity of people out there perhaps feeling a little bit misinformed about this and thinking, yeah, well, I can just wait for the law to change and it'll be fine. Because actually, when that reversion is so close, actually it's all about the term and all about the value of the reversion. We don't yet know what the capitalisation rate and the deferment rate will be in the new world. And you rightly picked that up earlier on, Chris. That's another thing we're waiting for government to tell us what those rates will be.
That's likely to be controversial in itself, isn't it? There has been a lot of talk about challenges under the human rights angle for changing the deferment rate and the impact that that's likely to have. Because anecdotally, I'm not going to go into detail now because, as Mark said, we're bringing it to a close. But if at the moment, the deferment rates are set and have been set for the last 20-odd years at 4.5% to 5%, depending upon whether it's a flat or a house. The economy has moved on in the last 20 years considerably. So if you change the deferment rates, and bringing the deferment rate down will have the perverse effect of increasing the premium that you might expect to pay, it could become more expensive for people to extend their leases where they have more than 80 years than they do at the moment, which is just not what Parliament intended.
No, clearly. So there's something else that needs to be, we need to wait and see on that, definitely. So it's very much a case of watch this space, isn't it? Very much so.
We like to think we know a lot, but we don't have all the answers around leasehold reform, unfortunately.
We don't have a crystal ball, that's for sure. Well, Chris, thanks for coming to talk to us this morning, and it was good to chat. And
Thank you very much.
Lots of stuff for another show. So.
Absolutely. Well, there's quite a few things that we didn't touch on there. The 87 Act, the right to manage. So it's definitely got some other things to talk about.
Indeed. Right.
Okay. Thank you.
That's all for today's episode of Listen Without Prejudice. Whether you're navigating a property transaction, a corporate, commercial, or family matter, we're here to guide you every step of the way. If you enjoyed the episode, don't forget to subscribe to stay up to date on future episodes, where we'll continue to explore the latest trends and challenges across our core practice areas. Do you have a question or topics you'd like us to cover? Or do you want to reach one of our experts? Feel free to get in touch via LinkedIn or through our website, bishopandsewell.co.uk. Thanks again for tuning in. Be sure to join us in our next episode, where the conversation continues. Until then, take care.